Hello and welcome to Kick-Ass Brand Show. I'm Andre Minkov, the founder of Trademark Factory. This episode is going to be very different from the ones I've had before. Today, I have for you Christi Tasker. She reached out to me by posting a comment on one of our YouTube videos and said that she had an incredible trademarking story to share with the world, with an unusual resolution. To introduce Christi, she wrote a first-of-its-kind book on social media marketing titled Power of Pinterest, when the platform was still in its infancy. As a serial entrepreneur, Christi owns two marketing and branding firms, ButtonOut.com and TaskerAgency.com. Her digital marketing advice and expertise are often shared on networks such as NBC News, PR News Press, and Social Media Today. She's a regular contributor to TechCrunch and several other online social media and marketing platforms and publications. Christi Tasker is a successful entrepreneur who thrives on wearing multiple hats and holding multiple titles simultaneously. Among the first business professionals to begin capitalizing on the brand building potential of Facebook, she used her eye for design and expertise in marketing to grow her own interior design firm and retail store, along with her own Christi Tasker Miami brand store of fashion accessories and home decor. Traveling more than half of the year, Christi's lifestyle blog of P.S. This Rocks is a hit among interior designers and travel connoisseurs. This episode is Christi's war story, full of lessons that would be important for all entrepreneurs out there. Check this out. So Christi, welcome to the show. I am really curious to know your story and see what you got to share with the audience. Let's do this.
Yeah, Andre, it's definitely a story, and I love your channel. I'd like to say that first off. I love the information that you give to your viewers. And when I was reading one of your videos, I couldn't help but to share, this story, because I think it's super important for artists, designers, small business owners, regarding their trademarks. And it's really like about a location-based trademark. So I started a company called Wynwood Lab, and Wynwood is the name of an arts district in Miami that's worldwide famous for Art Basel, Switzerland. So the arts district started really around 2012. And so this was around 2015 that we opened Wynwood Lab. Mm-hmm. And we moved to Miami. We start this whole lab concept, which is basically to give artists an avenue to be able to sell their wares and sell their good, with the backing of such like sponsors of Elle Decor and other major publications. So it wasn't too long after we started, and we're uber successful, much more successful than I'd ever expected to be, because of the name Wynwood being in Wynwood. So people were constantly like searching Wynwood. And so it was basically an event space and the concept of collaborating different artists together. We applied for the trademark, got the trademark. Shortly after, we were served.
So educate me. Wynwood, is this like it's a common name? What is it? Where does the name come from? Because it's not familiar to me.
Yeah, it's an arts district, so it's the name of a district in Miami. Okay. So it is actually, like Las Vegas has its arts districts, so it's really just like a name of like Manhattan. So there's Manhattan. It's almost like if we would have started Manhattan Lab in New York.
All right.
Yeah. So like it's a big area. It's like 10 blocks from, city streets. And it just so happened to be that we were an early adopter of the name. Like we just, and actually it wasn't anything I really had to think about. I think of creative names for companies all the time and their collections. That's what I do for a living.
Mm-hmm.
And when this just kind of came about because my thought was, lab has been around for years, and that's really what we're doing. We're just testing like the market. It's a market test for interior designers, for furniture manufacturers, artisans of any kind, because art can be furniture, it can be design, it can be, the art on the wall behind me. It can be a variety of things. So the name was pretty generic in my duties of naming things. So I'm thinking, well, that's an easy one. So we apply for the trademark, we go under review, and that's when we got served from a company called the Lab Miami. And the Lab Miami was a co-working space. They rented out office spaces, and they just so happened to be located in Wynwood. Okay. They'd been around, I want to say since like 2005, but they originally started out on Lincoln Road in South Beach. So it just happened to be that we just kind of moved to Wynwood about the same time. They, in their mind, or, in their filings, basically they filed a lawsuit against us. Things turned pretty ugly pretty quickly.
Oh.
And yeah. And basically, our social media had grown really, really fast. The domain authority had grown really, really fast. And I think they thought, they're owned by venture capitalists. My husband and I, just founders of this other brand. And in Wynwood, there's kind of like all these artsy people that kind of aren't business people. So a lot of investors, landlords, really kind of take advantage of that artistic, creative field of, being able to like jump in, and if something's going well, everybody wants to own it, right?
Yeah.
So our domain authority outranked them, very quickly, and which normally doesn't happen. If you guys know domain authority,
takes a while to get there.
Exactly. So our domain authority was totally outranking them. Social media, we were outgrowing them. We had about 28,000 social media followers pretty quickly, all organic, all based on Wynwood, because the name was Wynwood. So everybody wanted to be in Wynwood. They didn't want to be in the Lab Miami.
Yeah.
Get it? And so they basically filed a lawsuit. They wanted our social media domains. They wanted our website. And they wanted our name, period. Like you would not, there was no state of confusion whatsoever.
All right.
And the only thing when we showed up, so here's what I did. We went in front of the judge, and they kept trying to do things. They kept trying to push things out. They know that I travel a lot.
So when you say we, who showed up? Did you have attorneys, or did you just show up unrepresented by yourself?
That's actually a great question, because I had to hire an attorney. It was not an option because we were in federal court. You cannot represent federal court, period. So you're looking at $55,000 right off the bat, to even get an attorney to represent you. So I needed someone when I was trying to find the attorney to understand what I was doing, and what, to understand the artistic side of the business, so that they clearly understood, and they needed to understand location based, they needed to understand digital, they needed to understand marks, which we know most attorneys understand marks, but it's the location, the details that they needed to understand. Yeah. And then the other thing really important for them to understand, and you're the first to know this, $25,000 was it. My husband was like, you have to settle for this, or you just have to give it up, period. Because we're not putting any more money towards this brand, because it was making no money. It's not a profitable brand yet. So we're not even talking about something that's profitable. We're talking about a brand that's supposed to help artisans and designers facilitate their goods to buyers. But this hasn't even happened yet.
Let me pause it for a second and take one step back. How long did it take for them to sue you from the time you launched?
About 9 months.
9 months. Okay. All right. Sorry. Let's go back. Yeah. So you show up.
Yeah. They had not. And this is, I had actually did a trademark search myself. So I went on to USTPO, which I do every time I go to create a brand or, anything for a client. Before the attorney looks into something, right? So before we just naming things, that's the first place I go.
Yeah.
So we've fortunately done all of our due diligence there. The one thing that I wish that I had an attorney when I had filed, because the area was so popular, but at the time I didn't realize really how popular it was. I wish I'd had them file, but yet like earlier than I did. That's the mistake that I made. I should have had it like the moment I thought of the brand, because I could have beat them to the trademark office. They had not even had a trademark. However, it's my understanding that there would have still been a conflict, still sued us because their name was older, just because of the age of the brand. However, so we go to court, let's fast pace here. We go to court and our attorneys had actually gone prior. My attorney was basically saying, hey, like you're running out of retainer. And I'm like, we've got to like resolve this in some way. So he was actually trying to back out of the case. And we really hadn't gotten anywhere. So that $25,000 had not gotten anywhere. So I basically said, Michael, we have to get this resolved. You promised me, like in some way, you knew, I was very frank with you and how much money we had to spend, and that we would resolve something so that this case is, whatever's going to happen is going to happen. So it was he basically filed against the court, and the judge basically said within not even 20 hours notice, I want to see you all in court tomorrow at like 2:00. And this is like 6:00 in the afternoon that we're getting this message from the judge. So she's like, I want you all there. So my husband, he's not good at dealing with things like that. So he's like, you go to court. Okay. So, and he had been the only one that this VC company had ever seen before. So when I showed up in court, they thought, the other party thought that we had tried to send a representative. They didn't realize like who I was, they thought, and they're like, well, Mr. or Ms. Tasker has to be here. And I'm like, here I am. And so basically the judge said, I need you to go in and I need you guys to try to resolve this, because neither of you are going to like the resolution that I have for you. And there is that, judges want everything off their docket, and this particular judge wanted to retire. To retire until this is off her docket. So she basically sent us into a forced mediation, because the other party, every time we would say, oh, we're available, they'd say they weren't available. It was like this ongoing thing for really like a good 9 months.
Yeah, there's a tiny percentage of cases that ever see the trial, right? They all want them settled out of court.
Exactly. So, but in this case, because they kept saying, oh, we're not available, there was a mediation date set, they would back out. So the judge basically ordered a mediation she gave us 7 days. Okay, that worked out for me, because I'd been trying to be, that was the whole process. So what they were trying to do is drain our retainer. Yeah. And ask for things from our attorney. So we were trying to be proactive. So, my attorney said, my client, has basically said, made every contingency to try to be here, whenever the other party, and then they cancel. And he basically explained the mediators even getting, really annoyed. And then they would say, oh, there's not a mediator that they like. And so she said, well, here's the deal. You have 7 days to get in front of a mediator. I don't care which mediator you use. She recommended the mediator, several mediators. And she says, she actually called them right there and said, you're going on Thursday at, 7 a.m. in the morning. And she basically said, you guys need to plan on being there 24 hours, whatever it is, and if you need to go into the next day, go to the next day. But this mediator is available for 48 hours. And you either need to walk out with it done, or basically, I think what she was planning on doing is like wiping away both of our trademarks. So we go into a mediation, very early in the morning. I think we started like 7:45. I'm not a person. I don't really like it.
No.
So we go in, and the one thing that I'll do is I'll say right after the judge ordered us to mediate, the other attorney, she decided, like, let's go into a room and just see, like where we're at with this. So the one thing they wanted to know from us is how far we were really willing to go. So I bluffed all the way home. I basically said, you know what, we've got funds behind us. I've got VC funds coming in, and we're taking this all the way. However far it needs to go, that's how far we're going. Right, Michael? And basically, because he's like, knowing like this is not it. And he's like, this is a huge risk. Like, I don't really like this. And I said, here's the deal. I have a gut feeling about it. They don't really have the money either, because they're getting funds from, they're having to get VC funds. They're they're taking community funds. And that doesn't look good, because they're proposing as a charity. And I'm like, and supposedly we're both trying to help people. So, and at this point, we didn't really know what they had for the state of confusion. That was, they would obviously never respond, because they kept saying they had more than 30 incidences of, state of confusion between our mark and their mark. In other words, people showing up for our venue thinking that it was their venue. That never happened on our end. So we're going, if anything, it's our people going to them and coming back disappointed. But as we knew it, that never even happened with us. Because otherwise, our clients would be coming in going, oh yeah, I just went down to this other place. And, but that wasn't the case, because, we were really good about sending our location out via Google Maps or whatever it may be. So we go into this mediation, pretty much, that's when everybody's required to kind of put everything on the table. And they have one tweet, one from a caterer chef that tagged at mention Wynwood Lab instead of at the Lab Miami. And I would argue, I basically looked at the gentleman and I said, I'm really sorry that this has happened to you, but I'm just going to tell you, we have celebrity chefs in our venue cooking on a weekly basis. And he's has probably seen those chefs, and he wants everybody else to think that's what he's cooking. That is on purpose. He did not mix anything up. He just thinks we're cooler than you. Sorry. That's big. So so we're sitting at this table and we're like, okay, what else other than this tweet? Like, what else? The only other things he came up with were from a freight company that tried to deliver furniture to them. But I don't know if you can explain, but that's not legit. That's not likelihood of confusion, because it's your own party, it's your own people, which even the chef incident could be argued that was, and that's basically what my attorney said, that can actually be argued. That's your own employee. Technically, it's your own contractor in your space that has tweeted. So anybody could actually do that. We could all get online and say, hey, let's tweet at the Lab Miami, and that would all be confused. But the real deal was they wanted to walk away with our domain, because it was very much worth, a good $50,000 to $100,000 for them to have the domain and for them to have media channels. So basically, in that meeting, the mediator basically, said, yeah, pretty much that's what they want. That's it. Yeah. And he's going to give that up? Nope, absolutely not. So, are you ready for what we did?
I can't wait. Suspense.
This is like the most unheard of thing ever, that to me anyway. My attorney was the attorney also for Rolex, and he had just done a deal with another company and Rolex. It was very similar. So he said, nobody's giving here. She's going to have her domain and have her website. And you, if something happens and she goes out of business, you will basically we will turn those websites and those social media domains over to you in the event that she goes out of business. However, you have to pay for her trademark, and we will do a perpetual license, which means a license forever for the Winwood Lab trademark, in which I own the license. They think, and basically they have to pay for everything for my trademark. Everything. We protect. It's the silliest thing ever. And they bought into it.
So basically you got a reverse license, right? So you sold it to them and got a reverse license back. Is that?
No, I didn't sell them anything. So
because you're breaking up. So yeah, you're breaking up. So it's,
sorry about that.
That's all right. Let's try this again.
So we did a perpetual license, and with the perpetual license,
from whom to whom?
From them to us.
But for them to have a license, they have to own it.
But we have it assigned to us perpetually, forever.
So you assigned it to them, and then they gave you back the license. Is that
Yeah.
what? Yeah. So that's what I'm saying. Yeah.
I mean, it makes no sense to me still to this day why someone would want that, other than if the domains were vacated. So the domains were vacated, they would have the first right of refusal, but they basically have to pay for everything for the trademark. So they had to pay for the trademark, they have to renew the trademark. If they fault in doing that, or if they go out of business, we also have a perpetual license for their brand. So it was mutual, both ways.
Yeah.
But they're the ones paying for it.
Good. I mean, look, this is actually not so uncommon a situation. It's somewhat creative because, I mean, look, you either fight each other to death until one just surrenders, or there's some mutual resolution when you realize how you can coexist. And what they accomplished on their end, the way I see it, is they cleared out the ownership. So on paper, they own it, and they get to put up with the fact that you're there operating legally. So everyone's happy. And I'm sure lawyers are even more happy on both ends, right? Because they got to a point when they get paid, and they got both parties in a situation when they both feel relatively happy about it. But it's a good way of dealing with this, because if there is a way for you to coexist, that's always a better resolution than relying on the judge making decision
Absolutely.
One way or the other, and which is totally unpredictable. But
there were a few things that I did learn in my, I think we were in the room 15, 16 hours. So this was not a quick process.
Wow.
Giving up quickly at all. Fortunately, in school, I thought I wanted to be an attorney. So and then I'm an editor as well. So one thing that everyone should know is when you are faced in that situation and you're being thrown documents to sign, a comma, a period in the wrong place can change the whole entire document.
Easily.
And their attorney was trying to do that to me in the room. So she was banking on that I was going to be tired. But what we did is we wore her out and we wore them out, because I came prepared with, obviously we called in lunch. No one was expecting we would call in dinner. I had brought like protein bars and, like protein shakes, like things with me. So I would say if you go into mediation, plan to be there for a good 24 hours. Don't give up, because that's really what they were banking on, was that we would give up. And there were probably 25 revisions to a document that they were trying to bring. It would have a comma in the wrong place. And so I would hold up the documents to the light and see what had changed from one document to the other.
Wow.
And that's how I knew where to go to.
So they
because, I
would
mean,
sneak. So they would sneak edits in without telling you.
Yes. And
What did your
you
attorney
know,
have to say about this, or were you not, or did you not have
he
to?
actually extremely at first, obviously my attorney at this point, the judge basically ordered him to represent me, whether I paid him or not. She said, basically, you should have taken care of this for her $25,000. Sorry, that you kind of didn't get the job done.
Yeah.
That was the way she said it. But basically I said to him, listen, if you'll help, get through this, I'll make sure that you're paid for your time in here. So it's a verbal agreement. Obviously, I mean, I'm under contract with him, and I'm like, we just need to get finished. But I also need you to be happy with me. I want you to be patient. I don't want you to be like, just let her sign anything. So he actually got to a point, he had an intern with him that was his nephew. So he let him sit in on the case, which I love because I'm all about educating, the younger generation. And basically we kind of had a fun game out of it. We made a game out of like seeing if we could find their edits.
Wow.
And so he was actually standing over the other attorney as she was making edits, and he would catch her. And so after about the 20th time, she gave up and told him to sit down and start making the edits. And he did. So we were the ones who got to actually make the edits. Sure that like the commas, because there was a couple places she was trying to put commas that would have completely changed the meaning of the document.
Wow.
Where they would actually acquired ownership in a completely different way. So I would say, make sure your audience knows like everything really matters, and you have to be completely alert. Don't go into a mediation with a hangover. Don't go in tired. And hold your documents to the light, because even my attorney had never done that before. He's like, oh my gosh, that's brilliant.
That's brilliant. I actually have two comments about this. One is, so I was involved recently in a settlement for a client, and there was something very similar, very sneaky. I'm not sure if it was done intentionally, probably not. But we had an argument. So there was a paragraph there, and there was one word, foregoing. And initially it was foregoing with an E, which was supposed to say previously mentioned. And then in the final version, somehow the E got removed. And you could read that paragraph as my client just letting go of all of their intellectual property in that paragraph. Like, I'm not sure you really meant that, but if you did, no. And that was lots of fun because they are massive litigation firm, and me sending this to them, like they with everyone copied, like they were pretty embarrassed. So that was one thing. And the other thing that I wanted to mention is when you're talking about settlement agreements, there's two strategies around this, and I find that most attorneys go with a strategy of, okay, let's start with where we are and try to write a really long document from where we are now to where we want to eventually end up. And there's a second line I thought, which is the one I love to use, is it doesn't matter where we are now. The only thing that matters is where we want to be. So let's write the settlement from there, and we just, if we need to address something where we are now, we can, but it really doesn't matter where we are today and where we were yesterday, as long as we want to arrive to today. And most of the bickering, most of the fights are about today and yesterday, right? As long as there is agreement for tomorrow, this is where you should focus on. That makes life so much simpler. And that's exactly what you did with your settlement. Like, is there a way out of this? Yeah, you own it. We'll have a license to use it. How do we get there?
Exactly. And that's, we didn't really care, how that they own the license, as long as we have it forever, as long as we're operating a business, because it's not like we're going to, it is transferable. We can sell the business. There's nothing really they can do. to own the business unless the business is shut down. That's it. And the same goes for their business. So I said, okay, if you want that, we want to own your business too. And at first they're like, no, but why not? You're asking me for the same thing, and even my attorney, there were some things that he thought was a little ballsy, knowing, because, he knows that I have no more money to spend, right? And he's like wondering, oh my gosh, is this bill even going to get paid? But the reality is it's okay to bluff sometimes. And it's okay to ask questions. And even if there was a word I didn't know, like you were saying, like foregoing, if it was something that I annoyed them to the fact where I would sit there with a dictionary on my phone and just look it up and going, did you really mean this? And, just took all the time in the world. And, and again, I'm not saying made a game out of it, but I guess I kind of tend to have to make a game out of something, think of it as playing Scrabble in a big way that can affect the rest of your life, or affect your business. Because, I feel like a lot of people, and, and the mediator, my attorney, even the other attorney, like, had respect for me in the end, and a lot more respect for me when we left than they did when we walked in the door, because they knew I wasn't giving up. So I'll say this, since then, I have not received a single lawsuit. I haven't received a single issue from them. The other thing that I wrote in, or asked them to write in, was they can no longer sue us. We have to go to mediation. Like, if there is a problem, if a problem arises, we have to go to mediation, because they were very sue happy to begin with. Because, when we got the suit letter, even before we hired an attorney, we said, what's the deal? Like, you guys are here helping people. We're here helping people. Neither one of us are really making any money off of this. Definitely not yet. If there's even any money to be made. And we're both supposed to be like, you're supposed to be helping entrepreneurs. We're supposed to be helping creative entrepreneurs in a completely different way, in a different facet. When we have an e-shopping site, they have a co-working space.
Yeah.
I mean, our trademarks fall into two different classes.
Yeah.
It's like, so in that, just the ability of not giving up. But the reality is, and then even after the fact, what they did is they started bringing art. They tried to start mimicking what we were doing. But the reality is too, we had such a big brand built so quickly that we know, like, our audience is not going to confuse us for them, because our audience is much higher end and just a completely different audience than,
and you're making a great point. Well, there's actually two great points here. One is that, in theory, I guess you could argue that there was no confusion, that there was no overlap in goods and services, different classes, but they have enough of a case to make your life miserable, because it's not going to be thrown out of the court just like that. And you still have to spend resources and prove your case. Right. So there's you can do everything by the book. You can have the best trademark search. You can have the best trademark filing. There's still a risk that some idiot is going to go and attack you. Right. There's no 100% guarantee against that. But you filing that trademark does two things. One, it gives you a chance of having a good resolution to it, and B, it minimizes the risk of that happening to almost zero. It's never zero, but almost zero. So you're just one of those unlucky ones that got hit by that claim. The other thing I wanted to mention is there's this movie, one of my favorite movies with John Travolta, called A Civil Action. It's one of those obscure movies that you can't find anywhere almost anymore. And there's this, it's kind of a legal court drama, right? And there's a great saying from there. It says, here's how lawsuits work. You get parties to spend an exorbitant amount of money on lawyers until one party comes to their senses, and then it loses.
Yeah.
Right. So once you realize that you're spending more money on lawyers than you'll ever make with whatever you're arguing about, you're like, let's stop this, let's let it go and find a way to resolution. And that's when they lose, right? And so to your point about bluffing, right, you always want to create the appearance that you will outspend the other side, and that you'll go all the way. Because if they have a feeling that you're not going to go all the way, it's just as good as not starting it, because they will always outmotion you. They will always have one extra thing to draw you through, to drag you through. And if you can't do it, then you lose.
Right. And, in our case, they knew, I'm a travel blogger. Most of my clients, I help brands and artists come into America and host events worldwide. So they knew, I can't, I'm on social media. I can't not say, that I'm there. But what had happened in the case of the attorney making us, not the attorney, but the judge making us appear at the very last moment, was they were not expecting that we were even in town. We had just gotten back, and I had not posted that we're back. So they were totally banking on, she's not here, they're not here, they're actually in Europe, and no way she's going to be able to appear in court. And I think that's, they were pushing the judge, basically trying to say, we weren't making it out like we were the ones that were delaying, when it was actually them. So, she was very surprised. And that's the reason, when I was in court and they had told her, oh yeah, this person, that she's always out of town, always, traveling, and always has an excuse, and when I was there and they weren't expecting me to be there because, on my social media, they're seeing me somewhere else. They were thinking that they really had us, so that's another thing that you have to be, I think, super cautious about when you're in a case. They're watching every move you're making.
Let me ask you a question. So apparently you have a happy ending there. What would you have done differently if you knew what you know now?
I would have actually pressured my attorney, who was a super nice guy. I would work with him over and over again. But I would have actually pressured him a little bit sooner to close out everything much, much sooner than he did. And I would have said, just because we're the defendant, and the other thing, actually, in the very beginning, what I would have actually done is sued them. I would have been the plaintiff instead of the defendant. Because the one thing that I've learned is being the defendant is never a good position to be in. So I've never been a person who sued anyone in my entire life. Okay, until this case, I'd never really, I wanted to be an attorney in school, but never had considered suing someone personally or in business. It's always something that I've tried to stay away from.
And did they just sue you, or was there a demand letter first?
There's never a demand letter, never nothing. So, no, they pretty much, they came and they came to our business, and my husband even showed them around, because they're like, hey, we have the same name. And he's like, oh, okay, what do we need to do? He was actually, my husband's British. He's super nice. They don't sue each other over silly stuff like we do here in America. But he had basically shown them around and, said, hey, just let us know, what works for you. We'll, what part. And the next thing we know, we're getting a lawsuit. So his feelings were hurt, to be really honest with you, because he's like, but I showed them, it's not, totally different than their business. And, we have no interest, and we'll send their people their way if they ever come here. And we would expect they would do the same. But that wasn't working. That's not what they were after. They were not really after, playing nice. They were after those domains. So when I started looking into it, because even though I'm in digital media, being the owner of that brand, I'm kind of like the cobbler's wife, shoes, except for, I'm the digital media girl, who doesn't own her own brands the way that I do my clients' brands, because I'm more focused on them. So I would have probably, in the very beginning, I would have probably just gone ahead and sued them and been the plaintiff on the forefront, had I known that they were thinking, even considering, I would have probably, the day that they raised a question regarding our brand, I would have probably called an attorney and just sued them and they're not wanting to come to an agreement right then. But yet there's also the trust factor in that people aren't going to do that to you as well. But there is an upper hand if you are the plaintiff, as I understand now, that I didn't know. But then if I were sued, I would immediately contact an attorney like yourself who understands the case very well. I would be very honest with them again about the retainer and how much you actually have to spend and that you need to close things out. But I would have actually pressured my attorney a little bit further in the strategy that I wanted him to take versus what he had taken. But at the same time, maybe the perpetual license thing, maybe it wasn't in his playbook at the time. I don't know, So it would have definitely saved me a lot of money and a lot of headache had I known that.
Right. So that's a great story, and I really, really, really thank you for reaching out to me on the channel and following. And when you sent that comment, I'm like, what's the story? I'm so curious. And
anything to keep anyone else from going through the same thing. I'm all about if it will save one of your audience members from going through the same thing that I went through, because it's a lot of stress, a lot of headache that I would never want to go through again. Getting that trademark, if you see anything similar, documenting and, serving them with a cease and desist or something of that nature is maybe something that I would have done earlier on. I would have just consulted with an attorney earlier, even before I was served.
Yeah, because it's all about timing. It's all about timing. There's a great saying from one of the attorneys that we work with all the time on the litigation side. He says, people who want to sue. People who want to threaten litigation. Right? This is about the cease and desist letters, right? Because there's a category, they just send you the demand letter, you ignore it, and then nothing happens. So, if you're sending somebody a demand letter, you want to make sure you have the next step lined up, because if you don't take that next step, nobody's going to take you seriously.
Absolutely.
Yeah.
Well, and I'm sure that you've probably covered this 100 times too. The other thing that I thought that I could do is produce the answers myself. But even if even with my background and being able to write in attorney lingo, I still can't represent myself in a court, and no one can. So
yeah.
It's not even a choice. And I think that's an important thing to note. So I would say, as a brand owner and as a person who now advises brands, because none of my clients have ever been sued over their brand name. I've been in the business of naming things for over 10 years. And now the one thing that I advise every single client that I have, whenever they're coming up with any kind of brand name, I immediately turn them on to a trademark attorney to say, here, I can't advise you, here's what I'm finding on USTPO, but I highly recommend that you, either consult with an attorney that you have, but I would also recommend that you have a business trademark attorney on hand. Even if you're not going to use them today, just run this by them, pay them to file the paperwork for you, so that way they're aware of everything that can take place. Because at the end of the day, that $1,500 for you guys to file versus just trying to walk through the steps of doing it yourself, even though I can do it and it wouldn't have really changed a lot. But I think the average person, there's no way they can do it because they don't know exactly which class they fall into. And the class is actually what saved us, is that we weren't in the exact same class. But you guys definitely know best and can probably save people a lot of money in the long run.
One other thing that could help is having a business insurance.
Yes. Oh, yes. Thank you. We didn't have the right business insurance.
So that's the stuff that most business owners who start don't have. And if you had something like that cover for your attorney, you would have been feeling a lot better about the whole situation, right?
Yep, absolutely. Yeah, because I mean,
that's another lesson there.
That would have been huge. Yeah, I totally forgot about that. I didn't want to think about that.
Well, it's one of those things. Like, I wish I had that, right? Like, when you're looking at your house burned down, like, the first question people are going to ask, was it insured? Like, and imagine how it's going to feel when you say no. Right?
Exactly.
So it's the same thing with trademark, same thing with legal, and same thing with insurance. So, and I'm not selling insurance. I'm not. It's just.
It is important. It is important, though. It's super important. And I would say the other thing is, the business insurance. Yes, definitely. I totally forgot about that. That would have definitely covered my costs that I had to pay out of pocket and pay for the attorney's fees, which would have been great. And I would say, too, the brand that we had was a nonprofit. Not a nonprofit. Sorry, it wasn't a nonprofit, but it was a brand to just help people, because we didn't want to file for a nonprofit because we weren't really taking in donations or anything like that. It was just something my husband and I were doing. And just because you're doing good doesn't mean everybody appreciates it.
That's a great point. Yes.
Yes. So I'd say, like, any charities, like, sometimes I think people think with charities, or even, let's just say you're, knitting outfits for newborns, and you come up with a social media channel, and it maybe is like a bigger, maybe there's something bigger out there that you're unaware of. Yeah. In today's market, I think people get bigger organizations get happy really quick, and or they're also watching something that can be organic, grow really, really fast, and they want it, and they make an effort to get it. Yeah,
but think about this. Let's say you're, Make-A-Wish Foundation, right? You're doing all those nice things, but you have to be ruthless to anybody who's using your brand to take people's money that would not go to the children, right? And that's what brands are for, right? So just because you're a charity, just because you're a nonprofit, doesn't mean that you shouldn't be protecting your brand. In a sense, that's even more important, because if people don't know who they're sending money to, they're not going to send money to you, because they won't know if they're sending it to legitimate Make-A-Wish or a fake Make-A-Wish, right? So and that's something people often don't realize.
I bet you have a lot of, like I see a lot of, like, mom and homemakers that maybe they're not even taking in money, and all of a sudden, their good deed, let's just call it a good deed, not even a charity, goes viral on social media, but maybe that act is similar to a bigger organization that's doing it that they're probably, like, not even aware of, to be honest. But things can go viral really quick, and when that happens, sometimes that's when big brands or big companies with a lot of money step in, and they're like, no, we want this piece. We need this piece. This is what we've been trying to do. This is what we've been missing, and this is what we want. Yeah. Because, like, that with the Lab Miami, because they, after our venue, they brought in art. They brought in, like, prettier things, and before it was, like, literally like a coworker space without anything that looked nice. Like, you just kind of paid for your box, and that was it. And it was definitely a learning lesson for sure.
Wow. Well, Christi, like I said, thank you so much for sharing all this with us and with me and the audience. I think there's so many lessons here. It's definitely worth maybe even watching once again. Was there anything else you wanted to say before we wrap this up?
I can't think of anything else, but I guess if anybody has any questions, I'm happy to come back on your show and we can talk about anything trademark, that, from naming to anything else. I'm sure your audience will have tons of questions. I see you get tons of comments. And I love, watching your show and going down and reading the comments. I think it's the best trademark show on YouTube. that's the reason I said, hey, I'll share this story with you, because I definitely want to make sure that my experience and my $25,000 pays for something, education for someone. And I figured, you've got the audience of people who are looking for that type of stuff, and the stories that, like I have, that, my audience is, yes, they want it, but they're not necessarily out looking for that directly on my channel. They're more social media tips or travels, to watch the pretty things in life. They don't realize that all these other things are going on, because I'm very positive.
Yeah.
That's the name of my blog is P.S. This Rocks. So I try to keep things very positive and upbeat. And no one really knows about all of the other things that go down.
So how can people find you? How can they reach out to you? What's the best way? What's the website?
If you want to follow my travel blog is PS, like P as in Paul, Sam, thisrocks.com. And I also have my own jewelry collection, which I've just come out with.
Nice.
ChristiTask.com for that. And then if you're looking for social media tips, some people that may be watching this may see me like on NBC News giving small business owners social media tips on new social media sites. You can actually follow me there on putinout.com, and that's PUTINOUT.com, and pretty much on all social media, P.S. This Rocks, @PuttingOut, or Christi Tasker.
Make sure you send that to me so we can actually put a title so people can see it and click it, and we'll be happy to pass this on. Thank you so much for joining me today. I hope that you had fun sharing your story, and we'll get it out online pretty soon.
Yeah, awesome. Thanks for doing what you do, because I know it's not easy.
Thank you. All right, so off of this.
Really awesome. Yeah, you do a really good job of your videos and everything.
Christi and I would love to hear from you. What did you learn today that you're going to implement in your business? What lessons, what mistakes are you going to avoid? What's your biggest takeaway? Leave your comment below, and share this interview with your friends. And as always, please like and subscribe. And if you think that you deserve to be on the show because you have a kick-ass brand, you have a great story, email me at next@kickassbrandshow.com. And until then, well, you know the drill, right? I'll see you in the next video.